It is such a great pleasure to welcome you, Professor, as a guest lecturer to the CIL eAcademy. And also greetings to all our participants and greetings to those who are joining us from the public. We are really honored to have someone as accomplished as Professor Lee. And may I say that he's also a colleague from the Asian Society of International Law. We're on the council together. And we hope to welcome, Patricia and I, we hope to welcome Professor Lee as a new member to the International Law Commission in the next quinquennium. So Professor Lee, it's my pleasure on behalf of Patricia and myself to turn over the virtual floor to your lecture, which we all are very much looking forward to.
Well, good morning, good afternoon, and good evening to all of you. And I'd like to express my thanks, sincere thanks to Dr. Oral for her kind introduction of me. And I'd like to express my thanks to Matthew, Violet, and at the same time, Patricia, Professor Keun-Gwan, tell us as well. Well, it is my great pleasure and honor to be invited to give a lecture at the CI Center for International Law eAcademy. Well, this is, even though this is being conducted virtually, I'm sure, I hope that we can engage in very productive discussion. So once again, I'd like to express my sincere thanks for the invitation extended to me by the center. And at the same time, let me further mention two things. First of all, well, as was mentioned by Dr. Oral, well, we've been working together in the for the Asian Society of International Law, and I have the class list. I'm not going to go through this class list, but there I found quite a number of names from Southeast Asian part and Asian part, and of course from beyond as well. And so my pleasure is even greater, because I can see quite a number of active participation from Asia in particular. And today I'm going to talk about, the title of my presentation is a mouthful, isn't it, right? So historicizing, the ARSIWA, and it goes on like that. But before going into a rather detailed discussion of what I have prepared, and even more excitedly will engage in Q&A, very active Q&A. But let me just make a few, just a short personal remark. Well, I did my doctoral studies at the University of Cambridge in the middle of the 1990s, and that time around, my supervisor was Professor James Crawford, who passed away months ago. So I hope that, I met him for the last time when I gave a special lecture on the return of cultural property under international law at The Hague. It was 2018, so about 3 years ago. So I met him at his office, ICJ office. And so, we talked about our days together at Cambridge, and then he said that I'm very proud that I have produced 65 PhD students, and you're one of them. And so I told him, well, you see, and then we talked about the ARSIWA, Articles of State Responsibility. And then I said, well, you see, I'm sure that you're quite proud of Article 48, which we'll discuss today, right? And he said, well, yes, I am. So I told him that, well, probably we should get together. Your doctoral students should get together and probably name the meeting kind of club of Article 58 or something like that. He was happy about that. But there was the last time I saw him in person, and so I hope that probably today's lecture and Q&A to be conducted in commemoration of the late Professor James Crawford, with your kind understanding. Okay, right. So the agreed arrangements between me and the center is that I will talk for about 30 or 40 minutes, and then we'll go into Q&A. Right, and the title of my presentation is Historicizing ILC's 2001 ARSIWA. By the way, just a few weeks ago, 2 weeks ago, I had my left eye operated on, so my left eye is not working quite properly. So if I, sometimes squint and engage in some behavior rather abnormal to you, please understand. Please understand my situation. Well, so I have left eye handicapped, and my right eye is waiting for operation because it is one called that is suffering from high myopia. But I hope that my mind's eyes are quite clear and clairvoyant, hopefully. Okay, so and this course, this lecture is designed to be complementary to another lecture being given by Professor Bodo Levinek, right? And I haven't attended his lecture, and tomorrow we have another lecture, right? So I think he will provide a very detailed analysis and discussion of the 2000 ARSIWA. But in my case, I designed my lecture to be more historical and critical, and I hope that my lecture will provide you with another say perspective from which you can evaluate and analyze this highly important document. Okay, so historicizing ILC's 2001 ARSIWA, and the subtitle is locating its coordinates in the evolution of international law and drawing lessons for the future. And so here, what I'm going to do is basically three things. Let me share. Sorry, thank you. Okay, that's the title. Right. So reevaluating the Argo revolution. That's the expression used by Professor Alain Pellet. And Professor Alain Pellet, together with Professor James Crawford, they edited a book called The Law of International Responsibility, a highly important reference material. And there he used the expression Argo revolution. And in my syllabus that I provided to you, I used the expression Argo's turn, as it were. But we'll talk about that. So within the history of ILC, there was very radical turn in the work of ILC's work on state responsibility. So in the 1950s, there was Garcia Amador. He worked on this subject matter, but from a very different perspective. And then Argo came along. Argo came onto the scene in the early 1960s. In 1962 and in 1963, he produced a report. And this work, ILC's work on state responsibility, it took a completely different direction. So that is known as the Argo revolution. Oh, well, revolution is such a strong term, so I personally prefer to use the term Argo's turn, or maybe Argo's turn, right? So, and we'll talk about three things. First of all, what do you mean by Argo revolution? What is meant by Argo revolution? Expression Argo revolution by Professor Pellet. So Argo's objectification of international responsibility. So here, I'll address that soon. And then Argo's introduction of international crimes of the state. Well, this is almost nothing short of revolutionary, wasn't it? In the middle of the 1970s, there was a very famous or infamous or notorious article, draft article 19, which was produced by Professor Argo, which divides international wrongful acts of a state into international delicts and international crimes. And then, well, maybe this was not this. The last issue is not very well probably recognized, but there is another very important turn conducted, put into practice by Argo. That is Argo's repositioning of the law of state responsibility as the general rules governing the international responsibility of the state. So again, Garcia Amador and before state responsibility was approached from a very limited perspective. That is, the state responsibility for sufferings or damages caused to aliens or foreigners. But from early 1960s, that's Argo said that, well, the law of state responsibility should assume more systemic tint, as it were. And so that's the reason why he introduced the distinction between the famous distinction and controversial distinction between primary rules and secondary rules. So we'll go through these things and then try to critically analyze these so-called revolution. First, let me address this issue: objectification of international responsibility. Well, okay, what do you mean by this? It has to do with Article 1 and Article 2 and of ARSIWA. And here on this slide, I'm introducing Professor Pellé's argument, which is widely shared, by the way. So here, what I'm trying to say is that, well, the conventional wisdom about the law of state responsibility goes like this. First of all, well, the state responsibility was mainly civil. It was not criminal. And secondly, it was based on this kind of civil model, and it was mainly bilateralist, right? So the working assumption, the working premise of the IRC was that international law or international relations are composed of a whole bundle of bilateral relations put together. And so that's the reason why the law of state responsibility was not quite susceptible of concepts like obligations erga omnes or use cogents. That's the rather typical textbook presentation of the law of state responsibility. But here, Pellé says that, well, Roberto Argo, he did away with the element of damage for the arising of state responsibility, right? And so thereby he tried to objectify. And he doesn't pay that much attention of damage arising to relevant states, right? So thereby he objectified the law of state responsibility, and so from then on, the introduction of obligations erga omnes or jus cogens, it was possible, and it goes like that. But here, I'd like to share with you that, is it really true? So my simple question is, before the end of the Second World War, so-called during the classical period or traditional period of international law, first of all, how was the subject of state responsibility dealt with? Especially that time around, the authority of eminent scholars was very high, and how this issue, first of all, state responsibility was dealt with or addressed or approached by eminent authorities of international law. And in particular, that within the law of state responsibility, the concepts such as obligations erga omnes, it was not to be found in the 19th century or not, right? So the simple question that I'm raising is, right, this conventional textbook explanation concerning the contrast, dazzling contrast between contemporary international law as represented by, among others, ARSIWA, and the traditional classical period of international law. Is it really correct, accurate, factually, right? That's my first question. So first we'll look at look at that question, and then we'll go on to discuss the implications of such discussion. Well, my simple answer to that question, the question I raised, is that, well, you see, well, if you look at the 19th century books and articles, well, the concept of obligations erga omnes was fairly well established in the law of state responsibility. So, okay. And then, so here, well, first, let me say, let me share with you some ideas about state responsibility during the 19th century and in the early part of the 20th century. So in my syllabus, I use the expression, the normative matrix within which the law of state responsibility finds itself. Well, on one extreme, there were some scholars and practitioners, right, who denied the very concept of state responsibility in international law. Right. So here, Lassa Oppenheim, the famous book, right, his first edition of international law, a treatise. There, he talks about that view, and at the same time, and there was another French scholar, Paul Fauché, and he was highly he was an eminent authority, and he produced a kind of almost encyclopedic, very detailed, very detailed, at the same time very extensive treatise on international law. And there he talks about basically about the same thing. He's introducing such a view. That's not his own view, but he says that, well, under international law, there are some people who are saying that under international law, because there is no authority that is superior to sovereign nations. So the very concept of state responsibility does not exist. So on the one hand, such a view, right? And if you deny the very concept of state responsibility, then you run the risk of denying the legal character of international law itself, right? And that's the main question. That's the main question that really troubled, scholars in the late 19th century. So, we are getting there. But first, let us see some views. I'll just skip this part. Yeah, and okay. I'm sorry that because of my medical condition, I couldn't produce all these translations for these original materials, but probably for your convenience, after the class, I will provide you with some, at least summary translation of these materials. But let me just go into the discussion of this question. Right. So let me just adduce two examples. So here I'm dealing with the question of whether during the 19th century, there in the law of state responsibility, the concept of obligations erga omnes was there or not. Well, let me just adduce two examples, and these are authorities, very high authority. One is August Wilhelm Heften. His first edition. This book was highly influential, translated into French and all those things. And this was first edition. Das Europäische Völkerrecht der Gegenwart, 1844, and there it deals with state responsibility. Basically, what he says is delicts or torts, and there he talks about exactly this one. Obligations erga omnes. So if you violate, if you engage in this kind of, he's adducing 4 examples, and for instance here, for instance, the third one, or maybe the second one is if you violate the personal security of diplomats or diplomatic agents, then there's an action that goes against the whole nations. It violates the collective interest of the whole international community. Yeah? And the first one, it goes on like that. If a state tries to establish universal hegemony over Europe or other parts of the world, then that threatens to violate or encroach on the universal collective interests of society, international society. And I can easily adduce some more examples. And there is a Johann Caspar Bulunchili, and this book is fairly important. And the first edition was published in 1868, and the second edition appeared 4 years later. I'm citing from the second edition. And das moderne Völkerrecht der zivilisierten Staat als Rechtsbuch dargestellt. So it was one of the best examples of something known as private codification of international law. Well, in the 19th century, something known as codification of international law was in vogue, as it were. And this was one of them. And this was one of the most influential, Johann Caspar Bulunchili. And Johann Caspar Bulunchili, he was originally from Switzerland, and he was known as the spokesperson of European international law. So he enjoyed immense authority as an international lawyer. And this book, unfortunately, this is just hasn't been translated into English, but the French edition is available. But here, basically what he says is that, well, he talks about obligations erga omnes, and he goes on to present the list of obligations erga omnes. So you can find it again here. So, and in particular, in this art are of course like that. So he starts with sea robbery, piracy, right? And then it goes on like that, and then so he goes 5, 6, 7, 8, 9, 10, 11. These are just examples, and he produces fairly long list of obligations erga omnes. And if a state intentionally engenders a sanitary risk by propagating endemic or pandemic, so the die Gefahr einer Epidemie. So that's supposed to be one of the obligations erga omnes, right? So here I'll just probably I prepared some more slides, but probably well, due to time limitation, we can't go into all the details of this discussion. But here, what I'm trying to say is that, well, see, the development of international law, especially in the field of state responsibility, was not unilinear. It was rather cyclical in a way. So, as we saw here, during the 19th century, there are examples, right, of high authority that clearly provided for the obligations erga omnes. And what happened then? Well, around the turn of the century, from the 19th century into the 20th century, well, there was let me be very brief about this. There was a kind of a movement to anchor the whole structure of international law on states' will, right? And so Heinrich Triepel was really influential scholar in that regard, and Dionizio Ancelotti, who had a huge impact on the law of state responsibility by producing his magnum opus, 1902 magnum opus, right, in 1902, right? He was in a way, he was keenly following Heinrich Triepel and German scholars' discussion in that regard. And so, to make the long story short, Ancelotti's conclusion was, well, so now we can build our international law scientifically, not on the basis of natural law, but on state wills. So voluntarist, positivistic reconstruction of international law was accomplished, right? But the limitation was because he was basing the whole thing on state wills. It was difficult to come up with natural law concepts such as jus cogens or obligations erga omnes. And of course, that approach was compatible with interests of some states as well. So that's the situation that unfolded in the early part of the 20th century. And then after the end of the Second World War, we saw something known as the return or rebirth of natural law approaches. So that's the reason why maybe we need to expand or broaden our horizon into the 19th or 20th century, so that we can locate the coordinates of the ARSIWA 2000 ARSIWA in the evolution of international law. That's my first point. So there, I'm inviting you to put your conventional ideas about the law of responsibility in brackets and revisit them from a historical and critical perspective, right? Okay, that was my first point. And then, well, I think I should speed up a little bit. And let me go on to the second point, right? And here, for instance, you see, before going on to the second chunk of my presentation, for instance, Emery de Vattel, he produced a magnum opus in 1758, right? Le Droit des gens. And when you read this text, you always come away with a very strong impression that this book is so modern. It is just full of contemporary relevance. And just 9 years before, in 1749, Christian Wolff produced another book, right? But if you compare these two books, just 9 years set them apart, but well, Vattel's book is so modern, and you can recognize the basic structure and the substance of international law, of the international law we learn today. And here, it was in 1758. There, he produces some examples of course, collective interests of the international community. So here on this slide, there you go, right? So if there were people who made open profession of trampling justice underfoot, who despised and violated the rights of others whenever they found an opportunity, the interests of human society would authorize all the other nations to form a confederacy in order to humble and chastise the delinquents. And in the specific field of diplomatic immunity, he produces some other examples as well. Okay, right. Okay, I think. And then let me go on to the second chunk of my question. That is, well, another component of Argo's revolution. I'll be brief in that regard. Well, there was, of course, introduction of international criminal crimes of a state. But that was such a revolutionary concept, which gave rise to a very heated controversy. And as we know that, well, 2000 ARSIWA has a much softened and softer version of that concept, right? Quite transformed. And you can find in Article 40 and 41. And well, I think it is generally agreed that this decriminalizing the ARSIWA was a wise step, right? So when it comes to the concept of international solidarity, I think Professor Alain Pellet is one of the most ardent proponents, but he accepts the 2001 ARSIWA concerning this decriminalization of state responsibility. So I think there is a general agreement in that regard, and there are quite a number of criticisms. Right? First of all, this wholesale introduction of the criminal element into the law of state responsibility would run the risk of destabilizing the current international relations. And the other problem was, of course, right, Article 19. It proclaimed the existence of international crimes of a state with great fanfare, but when it comes to the implications or consequences of this concept, well, there seems to be just not much conspicuous differences, and so that was another problem. And one can raise other problems as well. Yeah. But again, I'm just sharing with you. I'd like to share with you. So let's look at the 19th century again. So in the 19th century, was there criminal conception of state responsibility or not? I haven't carried out an extensive research in that regard, which I will do later. But there seems to be. Let me just share with you some slides. First of all, again, there was a Hefter, 1844 Hefter's book there. Here, he clearly says that, well, in international law, in public international law, there cannot be such thing as criminal responsibility. So he is rather clear about that, right? But in contrast, I think such a view was more prevalent. But let me share with you Chile, 1872. Here, this is highly interesting part. There he says that, well, you see, what he says here is that, well, in the domestic law, it says that, well, there's access of Strafrecht. Yeah. So basically what he says that, well, there's corporations or maybe partnerships, they cannot bear criminal responsibility. That principle is recognized in domestic law. But here he says that, well, that principle cannot be applied to international law. And international law, this concept, the criminal concept, can be applied. So if a state engages in invasion, right, then that state can be annihilated, out of existence, brought out of existence, and that's a kind of criminal sanction. So, well, yeah, that's yeah. I don't know. This could be not controversial, but let me just say that. Well, so first of all, important thing to bear in mind is that, first of all, in the 19th century, there was some inquiry into the nature and character of state responsibility in international law. So there are some views who clearly denied the criminal character or criminal nature of state responsibility under international law, but there were. I think this was rather minority view, but there was inclined to accepting such a conception, criminal conception of state responsibility. So let me just concerning this question, let me just stop there, and then let's move on to the last component of my presentation. Well, so here we are talking about Argo's revolution or Argo's turn. And another important thing is that, well, Article 54, measures taken by states other than an injured state. And there is another provision, right? And in part 4, there is Article 55, there is a lex specialis. So here, we are going to address the question of the ARSIWA, the relationship, normative relationship between ARSIWA and other special areas of international law. Right? The reason why I'm raising this question is, right? So first of all, again, let's turn historical. If you look at the history of codification of international law in the field of state responsibility, an interesting thing is that, well, from the late 19th century until the early 1960s, as far as codification of international law is concerned, the law of responsibility was approached in a rather limited way. So, for instance, 1900, Neuchâtel, Institut de droit international, well, it dealt with, règlement sur la responsabilité des États, right? Not as a whole, state responsibility as a whole, but very specifically focusing on la raison des dommages, damage suffered by foreigners, aliens or foreigners, in case of, all this civil strife or insurrection, and civil war and things like that. And that basic tenet or approach was maintained by the League of Nations. So, as you know, in the year 1930, the League of Nations convened the Hague Codification Conference of International Law, and 3 items were dealt with: nationality, territorial sea, territorial waters, and state responsibility. And again, state responsibility was not approached or discussed from a general, comprehensive perspective. Again, it was rather limited on the question of the responsibility of states for damage done in their territory to the personal property of foreigners. And it was on that footing, it was on that basis that the ILC, newly constituted ILC, continued its work, its codification work on state responsibility. And this is rather well known, right? So Garcia Amador, special rapporteur, he worked on this subject from 1956 until 1961. And the title was Responsibility of the State for Injuries Caused in its Territory to the Personal Property of Aliens. And come 1962, 1963, things changed drastically and radically. That's another component of Argo's revolution. Right? So, and here I'm quoting from the subcommittee. So Argo was chairperson of this subcommittee, 10-member subcommittee, and they revisited this project of state responsibility, right? And then they decided to give priority to the definition of the general rules governing the international responsibility of the state. So here, before it was focused on a specific theme. So one can say that up to this point, the approach of the ILC to this subject matter was thematic. But from now on, the gaze, as it were, to be, if you allow me to be a bit literary, the gaze of the ILC's gaze on this subject matter turned more structural or architectural. So now it deals with general rules governing the international responsibility of the state. And that's the reason why the introduction of primary and secondary rules was necessary. And the rest is history, right? And then, okay, all right, we all know that. But what does it imply? Does it have any practical, theoretical, and practical implication? I think it does. So let me address that question with you. Okay. So now the question becomes, with this turn, right? With this change of tack, or maybe change of direction, promoted by Robert Argo, then a number of problems arose, and one of them is one can raise questions concerning the systemic status of the ARSIWA within the general architecture of international law. So pre-1963, the law of state responsibility had a rather limited material scope. So this subject's impact on the architecture or structure of international law was rather limited. But now, from 1963, the law of state responsibility appeared as the general rules governing the international responsibility of the state. So the systemic relationship between the ARSIWA and the special areas of international law, legis specialis and self-contained regime, that's the expression used by Zimmer, comes to the fore. So, for instance, Zimmer and Pokowski, they go through these 4 case studies. So, but ARSIWA, when it comes to ARSIWA, there are some parts of ARSIWA that can be applied to other parts of international law without any problem. So, for instance, when it comes to rules concerning attribution, or circumstances precluding the wrongfulness of conduct. So there, these are rather rules of general applicability. But the most controversial part is countermeasure. So diplomatic law, the ICJ in its Tehran hostage case, it said that, well, the 1961 Vienna Convention on Diplomatic Relations is a self-contained regime. Right? But if this regime proves not effective to some extent, then the countermeasures as provided for in ARSIWA, do they kick in as a kind of fallback sets of rules? What about the European Union legal system and the WTO system? There's much discussion, right, on this question, the relationship between, especially the Swiss Settlement Understanding and ARSIWA, and more importantly, in practice, treaties for the protection of human rights. So when it comes to treaties for protection of human rights, they usually the mechanism in place there is reporting procedures and individual communication system. If they prove to be ineffective, then the countermeasures as provided for in ARSIWA, do they kick in? And this question becomes even more important. And this was, and especially Article 54 of ARSIWA was a very important issue. So the question of enforceability of human rights has remained most controversial, so much so that it almost jeopardized the adoption of the final drafted articles by the ILC during its 2001 session, especially with the introduction by Article 48 of ARSIWA of the concept of obligations erga omnes. Well, obligations erga omnes and its cognate concept of jus cogens, they tend to enjoy a higher normativity, right? And it could easily trigger Article 54 by powerful states. So this raises a whole bunch of questions, and so there, so countermeasures as codified in the ARSIWA as mere lex generalis. Now, Article 51 used the expression lex generalis, but it's just a lex generalis and lex specialis, or countermeasures as codified in the ARSIWA is something more active and more aggressive that can be instrumentalized by powerful states. So I just coined this term now, lex vigilance, but yeah. So I think you understand my point, right? So now the question of the jurisdictional rule of reason between the ARSIWA and the special areas of international law, right? So how to calibrate the relationship between the law of state responsibility and the special areas of international law. This question arises. So that's what I meant by the, especially after the introduction of Article 48 and 54. How do you calibrate the systemic relationship between ARSIWA, especially countermeasures, and the special areas of international law, right? So so I basically, I'm saying the same thing here. So we need to look into these questions in more detail. Right, I think already spent almost more than 40 minutes if we deduct the introductory part. So I think I have to stop somewhere around here. So in my lecture, I discussed the implications of Argo's revolution. And so I dealt with 3 components. So first one was whether the current formulations of use cogents and obligations of ethical omnes, did they have their counterparts in the classical international law or not? Secondly, right, and another very conspicuous and well-known Argo's component of Argo's revolution, that is the introduction of criminal elements into the law of state responsibility. Does it have any precedence in the classical period of international law? And then thirdly, rather lesser known component of Argo's revolution, or maybe Argo's turn, is the generalization of the law of state responsibility, and what kind of impact does it have, and concerning especially the systemic relationship between the ARSIWA and the special areas of international law, in particular after the introduction of Article 48 and 54. Okay, so I hope I think I stop there, and we'll engage in Q&A.
Thank you
for your attention.
Thank you so much, Professor Lee. I have to say that was truly an absolutely wonderful lecture, truly erudite, and I use that word because you took us into a very deep dive, as they say, into history, legal history. And to be quite honest, I don't think we do that enough. And it really adds a dimension that may be lacking when we examine concepts that we think may be new. And you're so right, and when you describe that, it's more that when we're looking at the issue, the concept of state responsibility, it wasn't a concept that emerged in the post-World War II period, but actually took us back into the 19th century and even beyond that. And concepts such as erga omnes, jus cogens, state responsibility, and it's important to have that context. And so I think, I'm going to open it up for questions, but I want to just say that should we be really focusing more on legal history than we do often in the teachings, and how important that is. And also you raised this, which dates back to the 19th century and before, this tension between natural law and positive law, particularly on the question of state sovereignty. And you mentioned, of course, the writings of CIL and Hafter. And that still exists today. If you go into the ILC, we're still having that debate, and how that is reflected in the evolution of state responsibility, and whether the articles now have found a balance between this notion of purely positive and that of the natural law school of thinking. And it's interesting, we're still having that debate. So here are just some thoughts, but I have to say, I really enjoyed, I think you absolutely complimented very well the lecture that we've been having so far. And I do encourage our participants to either raise your hand or put, or I can't see, and I think perhaps Violet, you can help me if we do have some questions. If not, if you would just perhaps respond to the points I've made concerning, the historical, oh, I see, okay, excellent. Jill Anthony Aquino.
Okay, thank you, professors. Thank you, Professor Lee. It was actually a very thought-provoking lecture. I was just thinking about international criminal law and individual criminal responsibility, and how the World War II crimes were particularly handled through individual criminal responsibility. And I was saying through how you said, but before 1963, it was a very limited material scope in terms of state responsibility. But before 1963, or even before the 1940s, or during the World War II, is there already like a customary status for state responsibility or international responsibility for states for international crimes, as was controversial back then? Or is it really difficult to look at the crimes that happened during the World War II, either in Asia or in Europe, in the lens of state responsibility?
Oh, okay. Thank you very much. Well, thank you very much for your very thought-provoking question, Mr. Aquino. And let me first address some of the points raised by Professor Dr. Oral. Okay, maybe the use of history in international law. Well, all right, and I think while preparing for this class, I was a bit nervous about this, because you see, as you said, that we don't talk about history that much, and if we ever talk about history, if we ever discuss history in the classroom, then we usually end up having a very presentist foreshortening. So we say that, well, all the beautiful things happened after 1945. Look at all this Article 2.4 of the UN Charter, and the Rome Statute and all those things. And well, before then, it was kind of almost wasteland. I mean, exaggerating. And we don't. And in terms of concreteness of information, specificity of information, well, we have very detailed discussion of post-1945 period. But when it comes to 19th century or 18th century, and well, one of the reasons why I was motivated to present my lecture in this manner is this book, magnum opus by Professor James Crawford, right? State Responsibility, the General Part. It's very extensive, and I used it for my graduate seminar twice, and it's so rich in information. And chapter 1 deals with the history of state responsibility, right? And rather surprisingly, there's a very summary, very cavalier treatment of the 19th century, which is quite. I was rather struck by that. Well, 19th century is supposed to be the let's say the basic structure of modern international law was formed, and state responsibility, the concept of state responsibility, is so inherently connected with the legal nature of international law as a whole. But there was a very summary treatment of the 19th century. So that's one of the reasons why I try to embark on this intellectual kind of exercise, right? And so that's one thing I'd like to express. And at the same time, well, maybe my presentation of my lecture went across as a bit pedantic, always literature and all those things. But you can't help it to some extent. And so I think there should be more concerted effort to shed historic light on this question. And I think that's very important, because especially when it comes to Asia. There are quite a number of participants from Asia. Well, even China. And when it comes to, for questions like, I raised this question in my class, how can you characterize the relationship, international relationship between Qing China and Joseon in the 19th century? Well, all the terms we mobilized to discuss that question are all from modern European international law, which is not necessarily a problem in itself, but at the same time, to better understand East Asian international law, international law in East Asia, I think historic turn is in order, in my opinion. Okay, and thank you very much, Dr. Rao, for your very encouraging comments on this question. Right, and so, and you're quite right. See, you can't say that, well, pre-1918 it was all positivistic, and right. Well, if you look at pre-1918 practice and doctrine, well, there are quite a number of, especially in England, you can find quite a number of natural lawyers, naturalists. So it's not like, it's not unilinear development like that. That's the reason why I use the expression rather cyclical. Yeah, I'm not saying that it's just that remaining the same, but it's cyclical, and at the same time maybe it can go upwards. But yeah, okay, thank you. And going back to Mr. Aquino's question. Well, I mean, this is a hugely important question, right? So first of all, again, this has to do with the point raised by Dr. Rao. So what kind of approach will you take? And by the way, the same thing happened, the same question arose in the context of domestic law in Germany, right? During the Nazi Germany, right? If you apply positivistic approach, quite a number of atrocities were committed under the authority of positive law, right? That's the reason why Gustav Radebuch, he came up with his Radebuch formula. So if you start out from positivistic ideas and premises, then you can't just get away from that. That's the reason why he came up with this. He basically appealed to the old concept of natural law, and that's how he extricated himself, and probably with himself the German people from the positivistic how should I put it, Maya, right? So, and the same thing applies to probably to the question you just raised, right? So how do you evaluate this crimes against humanity? Or there are three items that appear as the Nuremberg Charter. Again, if you apply very dry positivistic approach, then one could raise a number of questions. But at the same time, if you look at the approach taken by the court, the tribunal, right? And well, you can't carry out your argument based only on these positivistic rules. Okay? So that's the reason. Again, we are back at the point raised by Dr. Rao. So even now, we are discussing these questions, and some people have more natural law leaning, and the others are more positivistic. But at the same time, you see, we are living in a period of global warming, and we are faced with real global problems. I don't know whether we can afford to stick to Hegelian conception of sovereignty, and we can still ring ultra positivistic, right? So probably we have to take into consideration that factor as well. So this is quite amazing, isn't it? Right? In the 19th century, the interface between these sovereign states was much narrower, right? But even that time around, people talked about the global community, or mankind, and there are some rules that should be observed to preserve that community. And in the 21st century, the humanity, which is faced with the really existential threat, can they really afford to be disregard those lessons from history? Okay, let me just stop there. And I see another hand there, Mr. Raphael.
Yes, hi. Can you hear me?
Okay.
Yes, hi, Professor. Good afternoon. Thank you so much. Very enlightening, historicized view on international law. It's a lens that I myself attempt to subscribe to throughout my efforts, and likewise a pleasure to be hearing from a fellow alumnus from the University of Cambridge. My question is quite simple, and it looks to this historical gap that I think is often overlooked. We look at the international law movement, the human rights movement, and of course ICL, to have taken strides from the crimes of the Nazi regimes, as Hill asked earlier, with regard to the crimes of World War II. Yet what we see is a gap between the 1940s and the 1960s, where these UDHR declarations, unenforceable declarations, all of a sudden took true positivist form, first through the ICERD and subsequently through the ICCPR. And I think that gap has been largely unexplained, and I would like to hopefully find answers through this discussion. What happened between the 1940s, where we could have a UDHR, very promising but non-binding, and 20 years later, what brought us to the adoption of the ICCPR and the like, and another decade to its effectivity?
Oh, okay, right. Okay, thank you, Raphael, for your highly interesting question. Well, probably, let me address your question, and then at the same time, let me also address the question that I haven't touched on in my presentation. That has to do with the final form to be taken by the ARSIWA, right? So I think there are some connections between these two sets of questions. So first, let me address your question. Well, right. So this has to do with, first of all, I think, first of all, one can maybe rephrase your question this way. So what was the added value by the adoption of the two covenants, international covenants of human rights, brought along in the 1960s, right? So, for instance, when it comes to the substantive list of human rights, as you find in the Universal Declaration of Human Rights, now is generally regarded as reflecting customary international law. So now it has attained the customary international law status, right? And you can find substantively rather similar provisions in the two international covenants, right? But having said that, there could be two differences. First of all, well, yeah, UDHR was adopted in the form. I'm a bit formalistic here. It was adopted in the form of the UN General Assembly resolution, even though it was titled Declaration, but it was a UN General Assembly resolution. So it was rather difficult for you to claim binding authority for this document. But 2 decades later, they were transformed into treaties, by definition binding on their parties, thereby strengthening or fortifying their binding authority or maybe normative status. That's, I think, what happened, first of all. And secondly, I think, well, if you look at these covenants, they have some procedural mechanisms, doesn't it? And a very powerful, symbolically powerful one is individual communication. Of course, you have to go through, we have to adopt the optional protocol, but at the same time, the symbolism of that mechanism was quite powerful, right? And an individual, a natural person, can, in a way, sue your own government before international authority. Of course, we always talk about the views, the binding authority, maybe the normative authority of the views handed down by the Human Rights Committee. Well, there was quite a number of discussion on that. But at the same time, the symbolism is very powerful. And then, of course, there is a reporting procedures as well, right? And then, even though it is rarely invoked, there is an interstate complaint procedure as well. So all these procedural mechanisms that attempts to operationalize the human rights ideas, substance of human rights ideas, as codified in the Universal Declaration of Human Rights. I think that's quite meaningful, even though we all admit that there are quite a number of problems and limits, without doubt. Okay.
Yes, Professor, thank you. I understand that we're past our time, but just to clarify perhaps the subtext of my question, it was, what was the historical reasons for, I mean, if we cite the crimes of the Nazi regime of World War II as so offensive and so shocking and disturbing that the international community was jolted to enter these new mechanisms, what was with the 1960s and 70s that jolted the international community to codify and make positivists, make positive the HR promises?
Yeah, well, I mean, well, you see, history is, our life is cyclical, right? So the same thing happened after the end of the First World War, right? So the interwar period, which is known as from 1919 until 1939, there is supposed to be a period of failure, because we had in 1939, on October 1st, on September 1st, 1939, there was bombardment of the city of Danzig by Nazi Germany. So they say that, well, you see, this 20 years, 2 decades, it went down the drains and nothing much to salvage from that experience. That's not true. That's not true. For instance, Hans Kelsen and other people, they had serious misgivings about the positivistic orientation of international law. And that's the reason why in the 1920s and in the 1930s, first of all, they set up something known as the League of Nations. And if you look at the doctrine, academic field, there are very many innovative ideas, like the subjectivity, international legal personality of individuals, and the highly important question of the relationship between international and domestic law. Well, Hans Kelsen went so far as to say that, well, logically, supremacy of international law, either supremacy of international law or supremacy of domestic law is possible logically, but from practical viewpoint, especially after going through this horrendous experience, right? Then we should push for the supremacy of international law over domestic law, right? And the same thing happened. The same thing happened in the after 1945, and one of the takeaways, as it were, after paying such a huge costs, and that's the reason why, if you read if you open up the preamble of the UN Charter, they talk about it. It sounds very personal, after going through 2 scourges in our lifetime. Well, I think that's not quite fair. You see, you can see that the draft of that preamble was rather old. But anyhow, after going through these 2 scourges, not one, 2 scourges during our own lifetime, then we have to do something about it. And one of them is, of course, if you suppress human rights, then it could lead to war. So that's the reason why you need, promote human rights. Yeah, according to some people, there was rather kind of ideology which was propagated during the Cold War, whether it's true or not, but there was the idea behind it. So the importance of human rights was fully established there. Yeah. So again,
Yeah.
it's great. Okay.
Wonderful. I'm afraid we've really come to the end of our time. We've gone over time. And Professor Lee, we're so grateful to you for indulging us with this extra time, but I think it was well worth it. I have to say that someone who actually loves history, I think it's so important to have that historical understanding that we often lack. And your lecture gave us that insight and a dimension that that really in detail, I have to say, in detail. So I hope our students have really benefited from that. I'm sure they have. And so Patricia joins me. We all join together in thanking you for this absolutely fantastic lecture. I think we will continue thinking about this for some time, actually. In fact, I wish maybe we need to have a class just on this.
Why not?
We may think about that.
Yeah,
and I thank also for the very thoughtful questions we've had as well. So having said that, thank you so much, Professor Lee, for taking the time to be with us.
well,
And Patricia, maybe you want to say something as well.
No, I fully agree with Nilofer. I think we need to discuss this this more. I mean, I had a very interesting for me going back in time in a way, because when I was studying in Geneva and going as a young student to watch the International Law Commission meetings when we were moving from the Article 19 on crimes of states to then to the approach of Professor Crawford. So for me, it was also something of a bit of a personal journey back in time when those discussions were very much alive. So I appreciate your efforts, and really was fascinating. We still need to learn from history and put it in perspective so that we can understand better the problems of the world today. So I'm very grateful to you, and on behalf of the students, we thank you very much for your efforts, especially considering that you had recent eye surgery and we know you're struggling.
Yeah.
And so we even appreciate it more. Thank you so much.
Okay. Thank you so much, Patricia. Well, okay. Well, once again, thank you very much for this kind invitation. And I enjoyed interacting with the students. And again, this is a kind of still, it's kind of work in progress. So I'd like to welcome, I most certainly welcome the participants in this lecture to contact me and continue our discussion and continue together our intellectual journey. And once again, thank you very much. And I wish all the best to all of you.